Good afternoon, everyone, and welcome. Thank you for joining us today. My name is Vishal Rai, and I'm the CEO of Visa Nation and your host today for this webinar. If you've been following immigration news lately, you've probably noticed a lot of noise and a lot of uncertainty. The goal of our webinar today is to move past all of that and focus on what actually matters. Over the past few weeks, most of the attention has been focused on the new $100,000 H-1B fee, but at the same time, the H-1B lottery itself is being fundamentally redesigned for the current fiscal year through a new wage-weighted selection process. So what we are seeing is not a shutdown of the H-1B program, but rather it's a shift away from randomness and toward a system that rewards preparation and thoughtful strategy. And those who do well in this new environment are the ones who plan ahead instead of reacting to headlines. And that's exactly why we are here today. During the webinar, we'll focus on a few key questions. For example, what has actually changed with the new $100,000 H-1B fee? What's the legal basis of this? Whether it affects only the new H-1B filings or also the amendments and extensions, and how the new wage-weighted H-1B lottery for the current fiscal year 2026 works. What are the things that employers and HR teams should be doing right now to plan, budget, and communicate to their employees? And how these changes fit into your longer-term planning, including green card, and when an L1 or O1 might make more sense. And one theme you'll hear throughout this webinar from us is this, that success in this new H-1B environment and landscape is less about luck and more about preparation, whether that happens in-house or with help from a business immigration firm. Before we begin, a couple of housekeeping notes I want to go over. Remember, today's webinar is purely educational in nature, and it's not legal advice in any shape or form. Immigration matters are highly complex, and they're specific to the facts and nuances of each case. Second, we are broadcasting live on LinkedIn and YouTube, so please post your questions directly in the comments in any of these two platforms. Our team is monitoring both, and we'll do our best to answer all of your questions in real time. With that, I'd like to introduce two of our attorneys joining me today, Shilpa Malik and Katiana Quindermill, who both focus on H-1B compliance, planning, and long-term strategy.
Thank you, Vishal, for the introduction. That was phenomenal. We appreciate you laying the ground for us to build on. As Vishal pointed out, this new H-1B processing that's being, or the lottery processing that's set to begin this year, has a lot of people asking a lot of questions, and we figured the best way to address those questions was through reaching out to the audience, answering a majority of the questions through our own Q&A, and then of course addressing any individual questions that are not specific to a certain case pattern or fact pattern, and being able to clear all the doubts that exist in the minds of employers, beneficiaries, as well as the HR personnel. That said, we wanted to show you some initial slides to essentially give you a roadmap of what this webinar is all about. And then we will be starting our Q&A with our CEO, where a majority of the questions will be addressed. So we can start with the first slide. So we're just going to quickly brush over the 100K fee. Please note that this 100K fee was introduced in September of 2025 by a presidential proclamation. It only applies to beneficiaries who are outside the United States, does not apply to any in-country H-1B filings for individuals who are in the US, and does not apply to any extensions or amendments, etc. There are certain exceptions to that, which we will cover during our Q&A. Now, legal risks and employer practicalities, please understand that there are lawsuits going on There's no confirmed decision yet. One of the federal courts did say that the Trump administration did have the ability to impose this fee. However, that's still being challenged. Hopefully, in the month of February, we'll have a more concrete decision. Until then, we should just assume that the 100K fee applies to beneficiaries who are outside the United States. And there are no exemptions for nonprofits or universities, but we'll cover more of that during our Q&A. Now, getting on to the most important question, which is the weighted lottery system, please understand it's a very structured way of doing things. I don't think this is a bad thing necessarily. It does reward higher wages for better positions within the H-1B landscape. And the number of possibilities or the number of chances of being selected in the lottery increase with the wage level, which again is something we'll go into in detail during our Q&A. Now, in-country advantage is one of the biggest advantages if the beneficiaries are in the United States on other legal valid status, which allows them to change their status to an H-1B. The 100K fee does not apply. There are alternative pathways. There's, of course, the O-1A or O-1B for qualified individuals, the L-1 for intra-company transfers. There's the TN for Canadians. There's the E-3 for Australians. There's the TN for Mexicans, and E-2s that are investment visas. Again, something that we would be happy to talk about more during our Q&A. Now, again, this is just a policy context. Now, please understand, people have to strategize. They have to understand, okay, what's next for us? Does the H-1B make sense for us? I do want to clarify the H-1B still makes a lot of sense. One of the best tools to get your work visas in for the right kind of candidates and for the right kind of positions by careful strategizing. We can now start with the Q&A, Vishal, if you're ready.
Yes, thanks for going over the brief presentation, Shilpa. And you covered from a high level what all has changed with the new $100,000 H-1B fee. So in practical terms, what do you expect to occur from a company standpoint that may be considering one of the two scenarios, either renewing an H-1B for an existing employee they have, and second, they may be interested in bringing in somebody who is currently abroad?
Well, thanks for that question, Vishal. So essentially, for somebody who's in the United States and seeking an amendment of their H-1B or a change of employer from one employer to another or an extension of their current H-1B, I want to clarify that the $100,000 fee does not apply. It is only for beneficiaries who are outside the U.S. The only exceptions exist if a person has fallen out of status. Just because you're in the U.S. doesn't mean you qualify for an extension or you qualify for a change of employer. You need to be in valid status in the United States at the time the H-1B is being filed in the U.S. If somebody is filing their extension after the I-94 expires, they just forgot to file the extension timely. Or if somebody has gone past the 60-day grace period, or they haven't complied with the terms of their H-1B by changing their work location and not informing USCIS of that change, those people will be kicked consular processing and they will become subject to the $100,000 fee. So that's very, very important that whenever an extension, amendment, change of employer is being processed, please consult with a qualified immigration attorney to determine, are we good? Are we subject to the 100K fee or are we not subject to the 100K fee? Because they'll be able to advise you, okay, where's this case going in the eyes of USCIS once it's submitted?
And what is the legal basis for this fee?
This is to protect American jobs. That's what the government has called it. It's very difficult to define an exact legal basis, but what they're saying is that they want to deter U.S. companies from hiring individuals at lower wages for positions that may not necessarily require a bachelor's degree. This is to ensure that the integrity of the H-1B program is maintained. Now, of course, $100,000 fee is absolutely ridiculous in our opinion, but that's what the government is, or rather the current administration is trying to say, that we are trying to protect American jobs or only allow H-1Bs for individuals who actually deserve them.
Are there any exemptions or carve-outs, such as like for universities, nonprofit organizations, or any exempt companies otherwise?
No exemptions have been announced as of yet. So far, as per the proclamation, every employer is subject to this 100K fee. They do have a very narrow category of national interest exemptions, that if the position is such that it benefits the national interest of the United States, then they may consider it. But in practice, nobody has been able to get an NIE yet. Just from our office, we have submitted multiple requests to the email address that they had proposed that these requests be sent to. It's been 3 months. We haven't heard back. So I really don't see any exemption taking place at this point in time. But again, every case needs to be reviewed on its own merits.
So just one follow-up to that. So what about the extension for those who are currently working for any nonprofit organization? Is there any difference in how they're treated versus those who are working for-profit companies when it comes to extension?
Again, extensions are not subject to the $100,000 fee, whether it's a nonprofit or for-profit organization.
So moving on to the wage-weighted process that's being announced starting from this year, how does the new wage-weighted H-1B lottery work? If you could give us some background on this first, that would be helpful.
Absolutely. So the Department of Labor, through its proposed rulemaking, and then, of course, the Department of Homeland Security decided to bring in this change for the FY 2027, which means the H-1B registration that we submitted in March of 2026 technically kick in as of October 1 of this year, which translates to fiscal year 2027. The registration process, or the registration window, still remains the same. It will likely be in the first 2 weeks of March. Again, we're waiting for the dates. It's not confirmed yet, but that's typically the timeline. USCIS will open up the registration window at noon Eastern on the first Monday of the month and close it at noon Eastern on the following Friday of the month. And then what it does is the employers create registration accounts and then go ahead and fill out the attorneys, if they have a legal representative, will fill out the registration application after doing all the initial groundwork to get to that point. Now, to get to your question about what the wage-based selection is all about, it's about the wage levels that are essentially assigned by the Department of Labor to a particular position. So each position has a standard occupational code, and then there's the geographical location where the beneficiary will be performing the work out of. So when we go and pick wages for a particular beneficiary, so let's say a company comes to us and says that this job, for this position, we are paying $80,000 a year, and the minimum requirements of this position are a bachelor's plus 2 years of work experience, or just a bachelor's degree. So then we have to first decide whether it's an entry-level position, is it a level 2 position, it's a level 3 or a level 4. Level 1 is generally for entry levels, for people who are usually fresh out of college and are starting their first job. Level 2 is for people with some years of experience on top of their bachelor's or master's. Level 3 is for mid-level employees, and level 4 is obviously for very senior level employees. If the company comes with an entry-level position and says that this is the wage we're offering, and the wage level for that position lands at level 1 as per the Department of Labor assignment, then that way, when we register that beneficiary for the H-1B lottery, they'll have one entry in the H-1B lottery, or max of two bites at the apple. One, if they have a master's or a higher degree from a qualified U.S. institution. So they first get put in the bachelor's lottery. If they don't get selected, they'll get one more chance in the cap, the 20,000 cap that is assigned to master's degree exemptions. And then this pattern follows for the other wage levels also. Wage level 2 will get 2 shots in the bachelor's lottery, 2 shots in the master's lottery. wage level 3 will get 3 shots in the bachelor's lottery, and if they don't get selected in that, they'll be put into the master's lottery and their name will be run 3 times. And then you go on to the fourth, which is the exact same explanation. So what this really means is the higher the wage level, the more bites at the apple you get. And whether or not you're counted in the master's lottery is strictly dependent on whether you have a master's or a higher degree from a qualified US institution. If you have a master's degree from a foreign university, then you would only be part of the bachelor's lottery. So in that case, with a level 1 entry, you'll get 1 bite at the bachelor's lottery. With a level 2 entry, you'll get 2 bites at the bachelor's lottery, and so on. So this is the wage-based selection. So what this really translates into, the higher your wages, the more likely you're to be selected for the H-1B registration.
So is it fair to say that employers can have more influence over the H-1B lottery selection under the new system?
Could you please repeat your question? I'm sorry.
So in light of this, is it fair to say that the employers can have more influence over the lottery chances for their employees under the new system?
Instead of calling it an influence, I would call it more of a strategic approach. Employers should, at least that's my recommendation, consult with qualified immigration attorneys to determine, okay, this is our position. These are the wages we are offering. How do we increase the chances by staying within the legal boundaries that have been put in place by the Department of Homeland Security and the Department of Labor? Are we willing to increase the wage level, or rather the wages, to bring it to a level 2 or a level 3, depending on how far the gap is between the two? So there's a range, obviously, on the wages. So strategic planning helps. And of course, with strategic planning, can you increase the odds of being selected? 100%.
So is the wage level or the exact compensation the only criteria that plays a role, or are there any other factors that an employer can potentially use?
There's no other factors one can use, and you shouldn't look for cheaper places of employment just because you believe that if I were to place this employee in a different county in the same state, I would have to pay lower, because USCIS wants to know that the employee is actually working out of that county at a legitimate address, whether they're working remotely. Then USCIS could make a site visit, or the Department of Labor could make a site visit to make sure the employee is actually working out of that location. So ideally, in fact, you should always pick the actual location where the employee is going to be working out of, determine the wage levels of that particular geographical location, and base your decision on that. Other than that, of course, you have to meet all the other H-1B requirements. You need to have specialty occupation work available for the beneficiary. The beneficiary needs to have a direct degree that's related to the position that's being offered. And last but not the least, it's a bona fide offer of employment.
So moving on now to the specific concerns and questions we've heard from our HR managers, director of clients, and employers. How should they approach the communication of these new changes to their employees in order to avoid any confusion or panic?
I wouldn't necessarily call this a situation that leads to panic. Again, as you rightly pointed out in your introduction, it requires strategic maneuvering. And if the company is willing to work with the beneficiary, this is in fact a good year to submit registrations. This is a very good year to submit registrations, because until last year, it was free for all. Hundreds and thousands of registrations by non-qualified people, hoping that, okay, we'll just try it, we'll get selected, and then we'll see what happens. But this year, it'll be planned, it'll be structured, and therefore, you walk into the lottery knowing that, okay, this is a good year for me. There's a very high chance that I'll get selected, and an H-1B can be eventually filed for me within the window after the selection results are announced. So if I were an HR manager, I'd be like, we are on your side. Okay, we are working with the attorney. We are going to come up with the best possible solution. We're going to try to do our best to give you the best shot at the lottery under all the applicable legal guidelines.
Okay, the next set of questions I have here, they're for Attorney Katiana.
Hello, good afternoon.
So, Katiana, when should employers or candidates who are interested in H-1B, they should consider any alternatives like O-1 visa or L-1?
Essentially, the sooner the better. If you believe that you could be eligible for any other type of visa, the sooner that you consult with an immigration attorney to discuss your options, or if you are any modification that you've made your application, the better. Because once you have that information in front of you, you will have a better chance at understanding if you will be restricted to the H-1B next year, or if there's other viable routes that you can take. And keep in mind, for other routes for immigration, you're not restricted to the same restrictions of application for H-1Bs. So if you were eligible for another visa, if you were to consult an immigration attorney, you'd be able to file that at any future time. It would not be restricted to the March registration period.
A follow-up to that, Katiana, is a lot of the same candidates are uh, who have in the past applied for H-1B lottery and they were not selected. Are there any common patterns in their experience, their resume, their background that make them stronger candidates for perhaps an O-1 visa? Could you cover, what are the things that the USCIS looks for?
There is no hard and fast rule. It would depend on each candidate and your credentials. There are certain requirements for oath. For example, you have to prove that you have achieved extraordinary ability, and that is done by meeting certain categories, certain criteria. There's other visas like a TN. Let's say you're a citizen of Mexico or Canada, and you're being offered a professional level employment, and with a qualifying position, you may be able to enter the United States. If you're working for, let's say, in a managerial or executive or specialty occupation position for a company abroad, and they want to transfer you into the US, the L1 visa is another possible option. But because of this, there is no red line other visa that aligns directly with the H-1B qualifications. If you're eligible for H-1Bs and you've applied in the past, it is advisable to consult with an immigration attorney to explore other options. There are many different types of visas out there, but it would depend. It's a case by case basis. So an attorney would have to review your credentials and determine what your future plans are, if you have any potential employers in the US, and where, if any, you would be able to fit in the United States in another category.
So many of these inquiries typically come from students who are in F1 and who are either in a graduate program or even PhD program. They're in the final stages of it. And they often seem to think that O1 is a viable option. Is there such an assumption? You want to comment on that?
Again, it would depend on a person's own credentials, because with an O1 visa, in order to demonstrate that you've reached the level of extraordinary abilities, there are 8 potential categories that you can meet, and you only need to demonstrate 3. So candidates who are studying they're about to graduate with their PhDs or other students, they may have qualifying experience that would help towards an O. But again, it's a case by case basis. Something to keep in mind: when USCIS determines if someone has risen to the level of extraordinary ability, they also have to do it over a sustained period. So many times that somebody hasn't graduated yet, or they're fresh out of school and they're fresh out of obtaining their PhD, there's a very small window of time that they have practiced their employment. So the smaller the window, the less likely it will be that USCIS will agree that they have sustained national claim. Now, again, it is important to consult with an attorney, because at such point, an attorney may be able to discuss a plan of action, what you can do for the next 6 months, year, 2 years of your life as you start with your employment trajectory, to be able to prepare yourself. So at a future time, you will be able to file for an O or any other type of visa. So again, consulting with an attorney would be the best option. That way you can prepare for what you'll be doing in the next 2 years if you were to proceed with another visa.
Thanks for covering that in detail, Katiana. One last question for you is, does this new wage-weighted selection process change or increase the the risks for audits or RFEs or any other type of scrutiny?
The scrutiny that all employers must be careful with is the H-1B registration. It can no longer be viewed as a placeholder. Just because, let's say, somebody applies for they register at a higher wage level, that higher wage level needs to be matched at the phase of the petition. So employers can't just decide that they're going to categorize this employment in a wage level, let's say wage level 3, to get more entries. They need to ensure that they're matching whatever level they're submitting a registration. It matches at the point of the petition, and make sure that they will be able to continue adhering to that throughout the life of the actual application. Will it increase the opportunity, the wage level, the on-site visits, the opportunities for RFEs? The true answer is we don't know until this March, but it is something to keep in mind, because employers need to avoid paying more just to try to raise the wage level. And because it's important to note that it's not just how much the position is being paid, but it's actually how the position is classified. So those are things that employers need to be careful with, and make sure that whatever wage levels they're submitting at the registration period, it is what they can honor at the phase of filing and throughout the life of the visa.
Great, thank you. We have one last question for Shilpa, and then we will open it up for questions from our audience. Shilpa, in your opinion, how does this change the long-term planning from the perspective of an applicant, whether it's related to their green card or perm strategy?
So this is a very interesting question, and I'll tell you why. While green card is a great option as a secondary long-term option, it's no longer a quick process. Those days are long gone. We're looking at about a 4 to 5 year wait from the time the process is started by a company till the person ends up getting a green card. There used to be a time when someone was on F1 OPT and already had a STEM OPT extension. They could use those 3 years to get the green card process started and eventually get their green card within that 3 year window without ever requiring another kind of work visa, because that F1 or the STEM plus the STEM OPT kept them in status while they were waiting for the green card process to be completed. Now we're talking about 4.5 to 5 years, given the delay at the Department of Labor level, the USCIS processing time, so on and so forth. And of course, let's not forget our applicants who are born in India or China. That's just not an option for them given the long wait times. Are there options like an EB-1A, EB-2, and IW? That's not within the scope of our webinar today. If somebody qualifies, of course, they should, again, pursue that with a qualified immigration attorney. But from a very standard processing perspective, when you do a standard perm-based process, you need 5 years. And you need an actual work visa to keep you going in the meantime, because the process itself does not give you any status until you get to the end of the process, which is the stage 3, which is the I-45 filing and then getting a work permit and whatnot. So in terms of strategy, you do need the H-1B, or you do need the TN, or you do need the O-1, or whatever L-1, whatever other visa that is applicable to your particular situation. Can the employer start the process in the first year of their F1 OPT or other status they hold? Of course they can, and they should if that candidate is somebody they wish to keep long-term, and if the candidate also wishes to pursue permanent residency. But this is not something that can be done in place of doing an H-1B or other work visas.
Okay, and in your opinion, is this a part of any broader immigration policy trend that we all can expect?
We don't know what to expect anymore. That is the honest to God truth. We wake up every morning hoping that there's no new announcement that will be made today that will obviously blow our mind. Having said that, we are good at adapting. We are all immigration attorneys. We learn, we grow, and we are here to support our clients. So can additional bombshells be dropped? Yes, of course they can be, but we're ready to take them on. And in terms of in order to answer your question, is this part of a long-term strategy? Yes, this is a strategy to control immigration. This is a strategy to prevent a lot of foreign workers from working in the United States. It's a strategy to discourage employers from hiring foreign workers. So that is definitely the long-term strategy here. But I would like to look at the silver lining in the cloud. This year is a great year to file H-1B registrations with the right approach. You do your registration correctly, you do it legally, you are ready to comply with what you submit in the registration, you have the highest chance of getting selected this year as compared to the previous years.
Thank you both, Shilpa and Katyana. Let's take some questions from our audience now. So the first one here is from someone with the handle Alvina. They want to know, how early can someone apply to extend their H-1B, and what are the steps under the current administration?
Well, the earliest anybody can apply for an extension on the H-1B is within 6 months of their I-94 expiration date. So you cannot start the process. I mean, you can start the process, but you cannot file the application with USCIS unless you're within that 6-month window. In terms of steps, it remains the same as the initial filing, just the fees are a little bit different. You don't have to pay the fraud prevention fee for an extension. And then if it's your second extension, then you don't even pay the ACWIA fee. But other than that, the documentation requirement is the same. And in fact, you need to really, really be careful when you apply for extensions. You have to make sure you've complied with the terms of your H-1B. You've done the job duties that were given to you. You've been paid your salary. You'll be required to provide your pay stubs and your W-2s to show compliance over a 2 or 3 year period, depending on when your last H-1B was approved. And finally, of course, the company still has the work for you to do for the next 3 years. You still remain qualified. Of course, nobody can take your degree away, but you haven't done anything to not comply with your H-1B terms. So that is still the norm.
The second question here also is related. So here, this person wants to know more about the timeline. If someone is still looking for an employer to be sponsored for an H-1B, is right now already too late for them to do so? What is the current timeline now for those who are seeking jobs?
I would say it's never too late until the registration period is over. If the employer is willing to work with you, bring this information to their attention, tell them that this is what's happening. I want to, if they have an immigration team, I'm sure they're working with the immigration team. If not, you can choose to introduce them to a lawyer you're comfortable with, and they can work with that lawyer in a very sort of short period of time, because if somebody who knows what to do, an immigration attorney who knows what to do, will be able to guide the employer very quickly, very efficiently, to get the registration submitted in the 2 weeks that the registration window opens up. Remember, yours does not have to be the first registration that gets in. Even if you're the last registration, you have the same amount of chances in the lottery. You need to meet the deadline. That's it.
Okay, let's move on to another question. This is about this is from Edgar, who wants to know more about how people on TN visa go about changing to H-1B. What's the process? What's the cost?
Well, it all depends. If you are on a TN and you're currently in the United States, or if you're asking for an individual who's currently on a TN who has valid TN status, you still have to go through the H-1B lottery to be counted against the cap. There's no exception to that, unless, of course, the position's offered by a nonprofit research organization or a university, private or public nonprofit university that's looking to hire you. In those scenarios, you don't have to go through the H-1B lottery. However, in order to change status from a TN to H-1B, and if you've never been through a lottery before, you'll have to jump through this hoop in order to get to the H-1B stage. Once you're selected in the lottery, your employer has 90 days to submit the H-1B petition, and once it's approved, your status will change from TN to H-1B effective October 1, or when the petition's approved, whichever is later.
Okay, the next question that I'm going to pick is about companies that are overseas and they're looking to potentially set up a presence in the US. This is from Graham. He wants to know, actually it's the reverse. Overseas company of US corporate company and then work there and then transfer on L1. So it's a bit of a strategy here.
The complication with that is USCIS is going to look at the overseas operations. They want to make sure you've had significant business operations overseas before you move the employee back to the United States. So if you already have an office in existence in a different country, yes, absolutely, you can move your employee as a functional manager or as an executive in a bona fide position again and bring them back in 12 months on an L1. But setting up a brand new company with a foreign office and then trying to bring them back in 12 months is going to require a careful review of all the documentation to show all the business operations that were conducted in that country in that 1 year period, including the number of employees this particular individual was managing or the executive authority he or she was exercising while at the overseas entity. So it's not a simple, let me set up a company, let me send somebody there for 12 months and then bring them back. There's a lot of scrutiny that goes into determining if that entity in whichever country you set up the offices in has actually conducted some very significant business operations in that country.
The next question is about any exemptions available. I think you've covered it already, but if you want to add more to that here.
I'm sorry, could you just repeat that question?
So this question on the screen is essentially something I believe you already covered, but if you want to add something about the exemptions.
Are you talking about, I believe this was for the TN to H-1B, am I correct?
No, this is a question about would it be exempt from the new fee?
What would be, I believe it goes the same person who asked about the change of status. I'm not following the question. Would it be exempt from the new fee?
Yes, someone changing from TN.
If they are in the United States and they're doing a change of status in the US, absolutely, they will be able to. They won't be subject to the 100,000 fee because they are in the US on valid H1, on valid TN status, requesting a change of status in the US. If they request consular processing, then they are subject to the $100,000 fee.
Okay, next question is from Sachi. I think it's also something we already covered, but I'll let you or Katiana add anything you'd like to add about advanced degree holders, how their chances stack up compared to others.
Katiana, do you want to address that one?
So Shilpa already covered this, but essentially, if you have an advanced degree such as a master's, you will get basically 2 bites of the apple. So let's say you were at wage level 1. You will get 1 chance at the wage level 1 regular lottery, and then you'll get it again in the cap exempt. Now, again, just having the master's will not change which wage level you're going to be placed in. But depending on after evaluation, whatever wage level you're placed in, that will give you multiple, it'll give you, let's say if you're wage level 2, it'll give you 2 entries in the regular lottery and then 2 entries in the master's lottery.
Okay. The next question is from related to HR. If the HR is concerned about the amount of documentation, which seems to be increasing, is there? I'll project the question here. So essentially, Nidhi wants to know whether immigration firms can help with most of the paperwork, so they can just focus on the decision-making and payments and other things that HR typically focuses on?
I would like to address that question. It depends on the immigration law firm. And frankly speaking, we would do all the work for the HR as a team at our law firm and ensure that we give them the advice that's best works within their business requirements as well. Because again, it's very important to strategize within what a company cannot do. So it's very critical to remember that. And if we are able to give them advice that helps them make the best decision to enter an applicant into a lottery, we will give them that advice. We'll prepare the documentation. And yes, they will log into the account once the documentation is prepared, and they'll sign off electronically on our submission, making sure that all the entries are correct and in compliance with what was discussed internally between us and them. And then we'll go ahead and submit it and pay the registration fee.
Another question that's more technical in nature is from Sanjana about the wage level 1 and how it connects with the location. So specifically, if someone is lower than wage level 1.
Unfortunately, then that person cannot be registered for the H-1B lottery because wage level 1 is the minimum requirement. So they need to have a discussion with their employer to bring them to at least a wage level 1. Now, remember, the H-1B wages are not paid as of the date the registration is submitted. The H-1B wages, as decided upon by the employer, are only effective after the H-1B is approved and after October 1, when H-1B actually kicks in. So the next 6-7 months between March and October are not a period of concern for the employer as far as those wages are concerned. But of course, if I list 80,000 as a wage level 1 on the registration while the beneficiary is currently making 70,000, then I would be expected as an employer, not expected, I would be required as an employer to pay them 80,000 after October 1st once their H-1B is approved.
So the next question is about the same topic of the wage level. This is from Akshay, who wants to know, how do they determine the wage level when filing applications for lottery?
They as in the employer, or are we talking about the Department of Labor? I'm not sure, but I'll address both scenarios. As far as determining the wage level, we do have an online wage library that the Department of Labor has made available to us. And when we are given, we are retained for the process, we send an H-1B questionnaire to the employer. They fill out the details of the position. They send us the job title, the job description. We then determine what's the best standard occupational code. And of course, we have the work location from the questionnaire, and we advise the employer of all the 4 wage levels. Of course, if the wage has already been listed on the questionnaire, we'll tell them, okay, your wage falls under level 1, level 2, level 3, level 4, whatever be the correct level. And then if there's a very marginal difference between what they're being offered and the next wage level, we'll also advise the employer to consider bumping them up to that particular wage level to increase their chances of being selected in the lottery. And as far as the Department of Labor and DHS, they'll of course verify the same source that we rely on to determine what wage level it was at.
Okay, so I think we have time for maybe 2 or 3 more questions. Since we are on the subject of wage level, I'll pick another one from Sanjana.
By total compensation or by base level pay only? Would you like to add anything to that question, Vishal?
No, please go ahead.
All right, so it is determined by whatever the fixed wages are. It cannot be a combination of base level and performance bonuses. A lot of people come to us, oh, I may get a $5,000 bonus at the end of the year. Anything that's not a fixed number cannot be included in determining the wage. So if there is a confirmed bonus that's given every year to all the employees within the organization, whatever number it is, yes, it can be added to the wage.
Okay. Here's a question that's been on the mind of multiple candidates. We've heard from people about the scenario where they have more than one job offer. So, for example, Ravi wants to know if multiple registrations are allowed from different employers.
So I want to clarify here, multiple and different employers are 2 different things. So each employer who has a bona fide offer of employment and is not related to another employer is in a position to submit the registration on behalf of a particular candidate. So let's say if I'm one of the beneficiaries and I have an offer from Amazon and Microsoft and let's say Apple, all 3 entities can submit a registration for me because they're not connected. But Amazon and AWS cannot submit a registration for me because if they are related or sister entities, and USCIS is of the opinion that somehow they're just trying to up the chance of getting a person selected, then that becomes a problem.
Seems like the wage level is the favorite topic on everyone's mind. We have a few more questions there. This one, I don't see the name of the person. It's just a LinkedIn user. They're curious about the range and the years of experience.
Again, it's very, very hard to define that. We have employers who offer, it's again based on the salary pattern within a particular organization. We have employers who offer people with significant degrees and work experience a fairly low salary because that's what their budget allows. And the employers like startups who are really eager to get good talent and bigger companies who really value some candidates, and they're willing to give them a higher wage level, even if they are just a fresh college graduate. It all depends. And this analysis is done at the time the attorney is retained, and then they're spoken to, and then after getting all the relevant information about the position and how the company wants to structure it.
Another one on the wage levels.
Everybody's put into the lottery at the same time. It's just that the number of attempts you get at the lottery, that's the only difference. They're not going to sideline a candidate just because, or a registration just because it's a wage level 1. It just means that, okay, you'll get in the lottery, but somebody who has a wage level 4 will get the same chance at the lottery 4 times over. That's the only difference. I do want to add one thing that USCIS and has said is that if they realize that there are just way too many level 1 registrations, then at that point in time, another lottery will be conducted to determine how many wage level 1s will be entered into the lottery. So it's a very complex web because it's a random computer generated lottery, but it's not like, okay, if I'm wage level 4, I'll get input first, and then I'll go to wage level 1. Everybody will get a chance, but of course, just because somebody's at wage level 4, they'll get selected, the number already will go down of the number of visas that will be eventually available.
Okay, so now let's move on from the wage level questions to other questions. Anthony wants to know how can a J1 visa holder who is transitioning to H-1B determine the specific year when they are allowed to transfer?
There is no such limitation. A person who's on their first year J1 can also apply for the H-1B the same year, or they can wait out the entire period of time that they are on J1. I would recommend obviously doing it depending on, typically for teachers and research scholars, et cetera, the term of J1 is about 5 years. And I'm just taking these two as examples. Of course, J1 has multiple terms in different scenarios, but you would want to do it in the second or the third year to see when they'll get selected in the lottery, especially if they're supporting a for-profit employer. But if it's a cap-exempt employer, then of course it doesn't matter. It can be done at any time.
And a follow-up to that from Anthony regarding the employers.
No ramifications whatsoever. If J1 has a limited term, plus you get another 6 years on the H-1B, plus the school or or whichever employer it is may choose to file a green card for them. So yeah, H-1B makes a lot of sense, and there's no ramifications whatsoever. Just be compliant. That's it.
Okay, I think we only have time for perhaps one last question. Let's see. It's about, again, the wage level.
If my current wage is slightly below the UFLC wage level 1, can I still participate? No. We won't even, if an attorney is representing your employer, they won't even submit the registration. There's just no way to submit that registration. You have to meet a minimum of wage level 1. That's it. It's as simple as that.
Actually, we do have time for one bonus question. It's from Pierre. Looks like he's already holding this visa and wants to know perhaps about H1.
C1D is for crewmen, and it's a very complex visa which does not allow for change of status. Generally, M1, you could, again, it comes with some very specific restrictions, which I'm not going to go into right now. changing from M1 to H-1B, et cetera, again, requires a very detailed analysis of your profile. Can it be done? Yes, from M1 to H-1B. But again, please consult with a qualified immigration attorney to ask these specific questions.
Well, with that, we are going to wrap up today's webinar. And I want to leave you with one key takeaway. The H-1B program is no longer about just the eligibility. It's increasingly now becoming more about the strategy between the new $100,000 fee and the wage-weighted lottery system. There are many strategic decisions here to be made by the employers. And it just makes the process more strategic rather than a yes, no, black and white decision making. So for many companies, the planning happens internally with their HR team, and for others, it requires or it makes it easier for them to seek counsel from external business immigration firms. Whatever your situation is, planning early is highly recommended in the current environment. If you have any questions you need further clarification on, our team is happy to continue the conversation offline. For that, you can either contact us by email, fill out a form on our website. And thank you again for joining us today, for your questions, and for engaging in this webinar, which affects so many foreign workers and employers. We'll be sharing the recording soon after the webinar, along with the presentation, and have a great rest of your day. Thank you.
Thank you, Vishal. I just wanted to add one thing. This is a great year for H-1Bs. Just if it's a possibility, then please pursue it, and please pursue it under the right legal guidance. Thank you.